From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court takes a case on alleged gerrymandering in South Carolina as Kari Lake jumps into the 2024 Arizona Senate race. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnist Alicia Finley and editorial board member Kate Batchelder Odell. The Supreme Court was back at oral argument Wednesday morning with another notable case, this one on the redistricting lines drawn by the state legislature in South Carolina. That map for U.S. Congress for those House seats, South Carolina has 7 of them, was challenged by the state conference of the NAACP, which claimed that 3 of those 7 districts were racially gerrymandered. That went to a panel at a district court level, which rejected the claims with 2 of the seats, but sustained it with regard to South Carolina's first House district that is anchored in Charleston and runs south along the coast. Let's start with a clip of Justice Amy Coney Barrett discussing the standard of review in these kinds of cases at the district court level and at the Supreme Court.
We're also reviewing it in light of the legal standards. I'm talking about factual. I'm not talking about the arguments that there was legal error here, but we're reviewing it in light of the fact that the plaintiffs bear an exceedingly heavy burden when they're trying to disentangle race and politics, and that we give the legislature a presumption of good faith. So we're asking whether the district court made a clear error in light of the fact that it was judging the factual record with those things into account.
Alicia, the phrase that I would pick out from Justice Barrett there is disentangling race and politics, because you have 2 stories that are being presented to the court here. South Carolina says that our goal in drawing this first district, which has been historically Republican, but for 2 years in 2018 and then from 2020 flipped to Democratic control, our goal in redrawing that district was to make it more Republican. So we moved out some Democratic areas and we moved in some Republican areas, and we achieved that goal. And the NAACP's argument is that the state map makers were essentially using race as a proxy for politics, which is what South Carolina denies. But it's difficult to make that distinction sometimes given racially polarized voting patterns. I mean, was South Carolina moving out Democratic voters who happened to be black, or was it moving out black voters who happened to be Democratic?
I think that's right. In many cases, blacks vote for Democrats, I think 90% of the time. So it's a pretty accurate proxy. This actually came up in North Carolina a few years ago when the legislature tried to claim, when it was also accused of essentially racial gerrymandering. Then they claimed that, no, we actually didn't consider race at all. We were focusing narrowly on political gerrymandering, which, if you recall, a few years ago, the Supreme Court said that they wanted to get out of this political thicket or adjudicating cases involving partisan gerrymanders. And that kind of actually created an opportunity for the state Supreme Courts then started intervening. So the North Carolina case actually ended up being decided or held as a partisan gerrymander by the state Supreme Court. But the Supreme Court has never actually weighed into this issue. What is partisan versus a racial gerrymander and how to distinguish between the two. And again, it's difficult because in many cases, at least, the blacks vote party line on Democrats. Hispanics are a little more heterodox, at least in the recent elections. And under the Constitution's Equal Protection Clause, the Supreme Court has held basically that you can't racially gerrymander. You can't try to pack too many blacks into one district. You can't focus heavily on race when you draw the map lines. The difficulty, of course, is also that the Section 2 of the Voting Rights Act almost also requires legislatures to also consider race when they are drawing lines and to create these majority-minority districts. But the Supreme Court's 1982 Gingles precedent, which kind of lays out how courts will consider whether there's a Section 2 violation, one of the 3 parts of the test is whether a minority group is politically cohesive or whether the minority group can demonstrate that the majority group votes sufficiently as a group to defeat the minority group's preferred candidate. And again, like when you have blacks voting as a politically cohesive bloc for Democrats, that's in a way helps the plaintiffs or progressives increasingly in these cases to demonstrate voting rights are Section 2 violation. But this also kind of muddies the ground when you're trying to argue over whether there's also an equal protection or whether there's an equal protection clause violation. So you're kind of stuck between you're damned if you do, you're damned if you don't. For a lot of these legislatures, you're going to get sued either way. And again, the Supreme Court now has an opportunity to kind of clear up that. In my opinion, yes, legislatures should be able to partisan gerrymander as they can, but it should be actually race blind. And again, this also brings in the Section 2 of the Voting Rights Amendment or Voting Rights Act, the Alabama case that the Supreme Court heard last term, and then another Louisiana case that the Fifth Circuit is kind of deliberating over right now.
My understanding of the case law here is that state legislatures, map makers are not allowed to use race as a proxy for partisanship. But again, that is what South Carolina denies that it did. And if you go look at the district court opinion, it cites one of the map makers saying, quote, he relied 100% on data regarding the partisan lean of the district. And so one of the questions at the court and at the Supreme Court is whether you believe those kinds of statements from map makers and state lawmakers. And the district court in this case did not. And one of the reasons that it did not, according to the opinion, is that before they redrew the lines, this first district was something like, I forget the exact figure, 17.8% Black. And after they made a bunch of changes in Charleston and also further south, the final district they came up with was also 17.8% Black. So the district court is saying, based on circumstantial evidence, we believe that the map makers were using that kind of racial target, and they felt that that was the figure they needed to hit. But to the point that Alicia made about damned if you do or damned if you don't, if the new map had lowered the Black voting age population in the first district, you can imagine that the state lawmakers and the map makers would have been sued over that. If they kept it the same, that's the situation we do have, and now we're at the Supreme Court. And if they had raised the Black voting age population of the first district, you can imagine a claim saying that, well, what you've done is you've taken Black voters out of the neighboring 6th district, which is held by Congressman Jim Clyburn, and you've moved them in the first. So you're making it harder for Jim Clyburn to retain his seat. So I think that's right. It does seem to me that map makers are sort of between a rock and a hard place when they're trying to make these kinds of decisions. And it doesn't help that, at least from a layman's standpoint, the Supreme Court's jurisprudence seems to be all over on these kinds of issues. And it's true that the law is different. So this is not, the South Carolina case does not involve the Voting Rights Act. It's a case under the 14th Amendment. But sometimes racial gerrymandering is banned, and sometimes it's required. This Alabama case, Alicia, that you raise is the one that the justices decided earlier this year, and that says that Alabama is required to draw a second majority Black district. And that now is being cited as precedent in the lower courts in a dispute that's going on over redistricting in Louisiana. And Alicia, I wonder if you can explain what that story is.
So back in the 1990s, Louisiana legislature actually tried to draw two majority-minority districts to comply with Section 2 of the Voting Rights Act. And both maps were struck down for violating the Equal Protections Clause, which is the one that's at issue in South Carolina. So the recent map that the Louisiana legislature, GOP legislature, drew after the 2020 census included only one majority minority district. And here the plaintiffs, which also include the NAACP, the ACLU, and some other progressive groups, sued and claimed that this actually violated Section 2 of the Voting Rights Act. And again, these claims were actually brought before the Alabama Supreme Court case, and that was heard last year and was just decided in June. And the case was actually put on pause while the Supreme Court issued that decision. And that decision essentially said, well, if it's possible to draw a second majority minority district and to preserve traditional redistricting or districting criteria such as compactness, then essentially legislatures are required to do that. And so the plaintiffs in this case are relying in part on that decision in Alabama, the Allen v. Milligan decision, to argue, well, Louisiana here should be required to draw a second majority minority district, and their plaintiffs experts that have proposed some maps that are actually very similar to the ones that the court struck down 3 decades ago for violating the Equal Protection Clause. So really at issue here and what the Fifth Circuit is being asked to decide is, well, what is again required under the Voting Rights Act? And is it proportional representation? Ergo that because Blacks make up about 30% of the population in Louisiana, or the voting age population in Louisiana, then they are essentially majority minority districts or majority Black districts must therefore make up about 30% of the districts. And now in the Alabama decision, Chief Justice Roberts basically said very clearly that nothing in this opinion and Section 2 actually explicitly bars proportional representation. That's essentially what the plaintiffs are asking for in the Louisiana case, and are actually asking for in many other cases, even though they try to disguise it. And so I think in the Fifth Circuit case, again, this was actually heard in oral arguments on Friday. The question is, what are exactly the limitations on, racial gerrymanders, and whether proportional representation will be essentially required. And again, this is a Fifth Circuit case, so it'll really only bind other courts in the Fifth Circuit, but other courts around the country and other circuits often look to what the sister circuits do. And so it's really kind of a test case. And I'd imagine it will probably be appealed either way up to the Supreme Court. The original sin, if I had to be honest, goes back to this 1982 Gingles case. That's the precedent. And I think that it's really kind of muddied the waters, and it's made it very difficult for legislatures to consider or to determine what is an illegal racial gerrymander and what is a legal racial gerrymander. And it's kind of as you mentioned, put legislatures in a rock and a hard spot. It would have been nice if the Supreme Court in the Alabama case had just kind of struck down the Gingles test for being kind of arbitrary. And I think that the Supreme Court is eventually going to have to square with it and decide whether to maintain it amid all this confusion that's creating in the lower courts and the contradictory demands by these plaintiffs groups. That essentially, if you get down to it, they essentially want legislatures to be forced to gerrymander in favor of the Democrats. And again, they're actually the ones who are using race as a proxy here in order to force maps that benefit Democrats. So it's ironic that in the South Carolina case that they're arguing basically against for what exactly they are doing.